Welcome to this global public lecture series, Decolonising Law, exploring the relationships between law, race, imperialism, colonialism, anti-imperialism, and de-anti-post-colonialism. I'm Ralph Wilde from UCL. This series has offered a stellar all-women lineup of amazing speakers. Already we've heard from Tendai Ichumi, Asla Bali, Vasuki Nasaya, Liliana Obregon, Mindy Chen Wishart, Aicha Chubuchku, Fabia Fernandez Carvalho, and Amaya Alves. Past lectures have addressed such issues as critical race theory and third world approaches to international law, colonial reparations, international law in the Americas, racism in universities, decolonizing the idea of humanity, intervention in Latin America, and nature rights and the Chilean Constitution. I'd like to offer my warmest thanks to my fantastic colleagues, Kat Balogan, Lisa Penfold, Jess Luong, and Danielle McFarlane at UCL Laws for their outstanding work in setting up the practicalities and the publicity for these lectures. Kat, Lisa, Jess, and Danielle, I'm so very grateful to you. Today, I'm delighted to introduce my dear friend, Vidya Kumar. Dr. Kumar joined Leicester University in June 2016. Prior to that, she was a lecturer at Birmingham University, a visiting research fellow at LSE's Centre for International Studies, and was a postdoctoral fellow at the Munk School for Global Affairs at the University of Toronto. She's currently a junior faculty member of the Institute for Global Law and Policy, IGLP, at Harvard Law School, and has recently been a visiting research scholar at the Institute of International Law and the Humanities at the University of Melbourne, and a visiting researcher at Humboldt in Berlin. She has a DPhil from Oxford, an LLM from Osgood, an LLB from Queen's, Ontario, MA and BA also from Kingston, Queen's as well, if I have that right, Vidya. And to mention two of her many important publications, her latest publications are On Scripts and Sensibility, Cold War International Law and Revolutionary Caribbean Subjects from the German Law Journal, and the entry for Revolutionaries in the edited volume Concepts for International Law, edited by Jean d'Aspremont and Saab Singh. Today, we have the delight to hear Dr. Kumar presenting on one of the main seminal contributions that she has made and is continuing to make in the field of international law on the fundamental subject of revolution. Do ask questions and make comments using the Q&A function here on Zoom for those of you watching this live. I will put these at the end of the lecture to Dr. Kumar without mentioning the identity of the questioner, which isn't possible for data protection reasons. And that will take place at the end of the presentation. So Vidya, I'm so delighted that you're here. Thank you so very much. And I'm greatly looking forward to your remarks. Over to you.
Wonderful. Okay, well, first of all, thank you. Thank you so much, both to Professors Wilde and Germendi for their very kind invitation to speak at this Decolonising Law series, which is such a prestigious and wonderful series with so many speakers that I admire and whose work I read on a regular basis. So thank you so much to both of you for producing such a groundbreaking series on decolonising law topics. I'm very excited to be here to think with you and the audience about revolutions and about international law. And in particular, I see a couple of friendly faces that I know in the audience, so thank you all for coming and for listening to me, or taking the time to listen to me and my ideas and thoughts. Now, on that point, these are just preliminary thoughts, is the first point I want to make on the topic. They've really been written and framed to begin a kind of intimate conversation, and not a really formal conversation about revolution and international law, with those of you who are here and who would like to participate with questions and answers. I am more than welcome to think these kinds of questions together when it comes to the question and answer period. Let me just put the my timer on so I make sure I am not going to go over. Okay, great. Okay, so my talk will touch on some broader epistemological arguments that I'm making in a chapter right now that I'm writing on revolutions for the Oxford Handbook of International Law and the Americas, which is forthcoming. And I'll be looking at various different Latin American revolutions, including Caribbean revolutions and their relationship to each other and to international law. In my 30 or so minutes that I've been allocated, my talk will take place in 4 parts. The first 2 parts will be quite short. And so part 1 will be entitled The 20th of April, 1959. Part 2 will be entitled The Occidental and Effective Revolutions of Hannah Arendt. Part 3 will be entitled International Law, Revolutionary World-Making, and Toward a Shadow Theory of Revolutions. And part 4 will be talking about the practices of epistemic justice. Okay, part 1, the 20th of April, 1959. 2 months after the Cuban Revolution triumphed in Havana on March 10th, 1959, Princeton University extended a formal invitation to the then 32-year-old leader of that revolution, Fidel Castro Ruiz, to address a senior conference of the American Civilization Program led by the Dodge Professor of History at Princeton University, whose name was Robert Palmer. Although at the time, US press coverage of the Cuban Revolution was still largely sympathetic in tone to the Cuban Revolution, none predicted the media frenzy that would ensue, with word of the event spreading far and wide despite attempts by Professor Palmer to play down the event. The date for the talk was set, April 20th, 1959, with access to the event restricted to only ticketed guests. There were 200 tickets that were distributed, 65 for faculty guests and students enrolled in the America Civilization Seminar Series. American and Cuban press jammed the hall. Castro was the first invitee or speaker for the 1959 Speakers Series, whose theme was, at the time in 1959, the United States and the revolutionary spirit. It's part 1. Part 2, the Occidental and Effective Revolutions of Hannah Arendt. Now, skip from 1959 to 1963. In this year, the political philosopher Hannah Arendt published one of her most famous texts on the subject of revolution, aptly titled On Revolution. I don't have time to discuss the whole work here or its groundbreaking nature. I'm assuming many of you know about it or have heard of it. But what I want to focus on is her chapter entitled The Social Question, as this is where her revolutionary thinking is most pronounced. I will assume that many here have not been familiar with her work, or at least this chapter. So I'll overview some of the main points of the chapter which relate to her primary textual aim, which is to theorize the nature of all revolutions through a comparison of the American and French revolutions. In this chapter, Arendt defines the social question to be what we may better and more simply called the existence of poverty. For her, poverty has been the driving force of most revolutions. Poverty is more than deprivation. It is absolute want. it puts its absolute want and its abject because it puts men under the absolute dictates of their bodies. That is, under the dictates of necessity. Ridding oneself of poverty becomes an irresistible force for those who are subject to it, a force which is a necessity of biological life. Like the motion of the stars, it's an elemental force in the world. Now, necessity for Arendt was the moving force of the French Revolution. It was what sent the poor onto the streets to liberate the life processes of society from the fetters of scarcity, to secure abundance, happiness, and life, and to deploy violence as the means to do so. For Arendt, the French Revolution failed or was doomed by its orientation around the inherently effective nature of the social question. That is to say, by the fact that the social question made compassion its organizing principle. What kind of compassion? It was a compassion for the low people experiencing poverty and scarcity, a compassion which required solidarity with the class of the poor who were suffering and who suffer. The consequence, legally speaking, of this compassionate foundation of the French Revolution was to permit lawlessness. That is to say, all is permitted in the name of liberation from poverty, as the sentiments of the heart underlying this revolution were legally boundless. So here she's saying that there were sentiments of the heart that underlied the revolution, and this made its nature legally boundless. She concludes by saying that since the French Revolution, all revolutions have followed the French Revolution model, and no revolution to date, when she was writing, which was 1963, no revolution solved the social question. That is the question of poverty and necessity. On the contrary, all revolutions of this sort end in both terror and failure. In contrast to the French model was the American model. And Arendt argues that the American Revolution went to war against tyranny and oppression, not poverty and scarcity. American revolutions, for Arendt, were not in solidarity with the people of a particular class. Rather, they were the people. They spoke and acted as members of a common cause. They were united not by solidarity with a particular class, the low class, in her words, but by the bonds of an objective cause, which was freedom. Their revolution, Arendt argues, was not based on compassion or passion, but on reason. It was not based on the particularity or the goodness which is inherent in the suffering of the poor, but on a general and universal claim to freedom from tyranny. Indeed, the aim of the American Revolution for Arendt was not abundance or liberation from scarcity, but freedom and reason. This aim was to be brought about by the free and deliberate actions of men, not the compulsion of necessity. It involved a violence of men liberated from necessity. So, of course, this kind of violence was a lesser violence, a good violence, one which was not boundless, as it seeks to preserve the meaning of life in a political sphere, rather than preserving bare life in nature. The American Revolution sought to pursue and preserve the legal rights of man and citizens, not the pre-political and therefore the lesser rights to biological existence or freedom from want. Part 3. It will be obvious to my audience here that I have not mentioned international law at all yet. So the question becomes, does the story I've told in parts 1 and part 2 of my talk tell us something about international law? And if so, what? Well, you won't be surprised to hear that the answer to this question is yes. These two parts of my talk, read together, I should say, are allegorical of international law's relationship with the Third World and with Third World Revolution. How and why? In the acknowledgements page of her work, her text on revolution, Hannah Arendt wrote the following, quote, "The topic of this book was suggested to me by a seminar on the United States and the revolutionary spirit held at Princeton University in the spring of 1959 under the auspices of a special program in American civilization." Arendt was indeed a participant in the 1959 seminar series at Princeton that inspired her seminal work. And it may surprise people here to learn that Arendt would have been present in the audience when Fidel electrified the Princeton crowd with his views on the spirit of the Cuban Revolution as an embodiment of a successful and modern revolutionary. So the question becomes, why is Cuba and the Cuban Revolution not mentioned even once in her text on revolution? Why are they not even in a footnote or not even in the index? Why is Fidel not mentioned? Why are his comments from his talk about his revolution not considered? In other words, how did Hannah Arendt make a world of revolutions in her text? How did she produce a world-making revolutionary theory without any third world revolutions? This question's allegorical value to contemporary critiques of international law may be a bit clearer now, as it is the same kind of question as the ones some international lawyers are now asking. How did international law tell the story about itself for so long that it made the world without including in any part of that story the third world? How did international legal textbooks and scholars tell a story about itself for so long that ignored third world domination at the heart of and facilitated by international law? Here, Bonaventura de Sousa Santos's work is useful here. He implores scholars and researchers to undertake a sociology of absences. That is to say, he suggested we should explore how the absence of the third world, or if you prefer the global south, is produced by knowledge practices in the global north. And he says this is because, quote, "the West or the global north claims the right to the dominant view of the world." Hannah Arendt's epistemic framework saw the revolutionary world made in two competing Occidental forms, the American and French Revolution. She chose to erase the Cuban Revolution as itself a world-making revolution, despite at least two strong arguments in favor of her including it. The first is the fact that Fidel kicked off the Princeton seminar series that inspired her work, charming the press, charming the audiences, the American audiences he spoke with. This would have meant the success of the Cuban Revolution was partly on her mind when she began writing her book. Second is the fact that Fidel himself, in his address for the series, expressly likened his revolution to the American Revolution. This was a claim that the Cuban Revolution followed or pursued freedom from tyranny, and it did not follow from the French Revolution, which he distanced his revolution from. This was something she could have explored, this claim, and she could have explored it even if she disagreed with it, especially as it was a claim that directly related to her claim about the social question. In fact, the lengths that she went to not speak about this particular revolution are remarkable in light of this, hearkening back to de Souza Santos's point that these absences are produced. Further, we should remember that while Arendt was writing the Algerian Revolution, which took place between 1954 and 1962 against France, was absolutely raging. She would have been well aware of both Sartre and Fanon's writing in support of the Algerian independence and of Camus' criticisms of it. And yet she does not engage. Why? Added to this is the 1945 August Revolution in Vietnam against the French and Japanese colonial rule, and the two Chinese revolutions of 1911 and 1945, all of which are more recent than the French and American revolutions. And each of these were, by the time she was writing, world-making in different ways. And then finally, and probably most significantly, or indeed most damningly for Arendt, is her omission of the Haitian Revolution, 1791 to 1804. It is damning, as this is more than a glaring oversight. The Haitian Revolution directly follows the French and American Revolution in its time frame. It is part of the same historical period as the French and American revolutions, which historians identify as the age of revolutions. And yet it deserves no mention from Arendt as a significant or groundbreaking revolution. These Third World revolutions, the Cuban, Vietnam, Algerian, and Haitian revolutions, I argue, can be characterized as shadow revolutions. They haunt Arendt's text and theoretical conclusions, and they call out for her work to be decolonized. They, of course, tell us something about her revolutionary thinking, but they also tell us about revolutionary thinking and scholarship in general, which fails to count non-white and non-Western revolutions as both revolutionary and as theoretically or empirically meaningful for knowledge produced on revolution, pun intended. These shadow revolutions, I argue, reinscribe the global color line in political theory about emancipation and change. And they serve as a generative allegory about what kinds of knowledge about revolutions is and has been and should be produced in international legal scholarship. So I argue, in order to have a rich and sophisticated understanding of the relationship between revolution and international law, we need to develop an epistemology that brings in and foregrounds revolutionary peripheries or shadow revolutions. We need a methodology which backgrounds white and Western revolutions in light of their overrepresentation and hegemony in legal scholarship and legal thinking. We need to ask and answer the question, would the story about revolution and international law change if we did this? And if so, how? The Haitian Revolution is valuable to the discussion about cognitive injustice because it complicates both the French and American revolutions and the stories told about these revolutions as contributing to the values of liberty and freedom and self-determination in international law and of advancing freedom of mankind. The fact that the Haitian Revolution was not only a story about independence and anti-colonialism, it was a story about those two things, but it was not only a story about independence and anti-colonialism, as the French and American revolutions were about, but in significant contrast to these revolutions, it was fundamentally an anti-slavery revolution. This was a revolution that first fought the French Republic, which still economically valued its colonies and the slave trade. This pits two different revolutionary visions against each other. Second, it was a revolution which American revolutionaries at the time did not support for fear of its threat to slavery in the American South and as a threat to the international slave trade. Just this brief discussion of the Haitian Revolution reveals that the French and American revolutions contributed to international law the value of slavery and domination of Black bodies in French colonies and in the domestic landscapes and politics and policies of America and France. This is merely one example of how a non-Western, non-white revolution complicates the narrative told about what American and French revolutions have contributed to international law, and how the story that these revolutions advanced universal progress and freedom must be qualified. These were not revolutions advancing universal freedom of humanity. Instead, these were revolutions which enforced and reinforced the global color line of the international legal order. In essence, the shadow theory of revolutions I'm proposing here underscores the importance of considering and of centering the contribution third world revolutions have made or can make to the development and understanding of international law and international legal thinking. Shadow revolutions often form the background of the most important and famous international legal cases. As Efthymios Papastravridis wrote in his chapter for the edited collection on Latin America and the Court of Justice, the Court of International Justice, he notes, if there is a case in public international law that every law student remembers or is called to remember, it's the Nicaragua case of 1986. As many in the audience will know, this case dealt with a number of significant issues in international law, including the sources of international law, the formation of international customary law, questions of international responsibility. But it is a case which has contributed arguably the most to the development of the field of jus ad bellum. For those who are not international lawyers, jus ad bellum is the branch of law that defines the legitimate reasons a state may have to engage in war or the use of force, and it focuses on certain criteria that render a war just. In this case, the International Court of Justice, for the first time, found that the use of interstate force had been prescribed not only in the UN Charter, but also in international customary law. To be clear, the important point I'm making here is not about the law of jus ad bellum. It is about the fact that a third world revolution was the underlying reason for this case in the first place. Without it, there would have been no case. The Nicaraguan Revolution, which lasted 28 years, starting in July 1961 and ending in April 1990, this history of this revolution is very fascinating and little known. The United States occupied Nicaragua from 1912 to 1933. This occupation was part of what was called the Banana Wars, when the United States military invaded various Latin American countries from 1898 to 1934. And the reason for the occupation and American military intervention in Nicaragua was to stop any other nation except the United States of America, from building a Nicaraguan canal. Following the occupation, the Somoza family and its political dynasty came into power and would rule Nicaragua as a dictatorship from 1937 until their ouster in 1979 during the Nicaraguan Revolution. So hidden in the background and in the shadows of this famous ICJ Nicaragua case, the case that clarified contemporary rules on the use of force and the peremptory norm of non-intervention, is a shadow revolution whose goal was both to end an oppressive dictatorship of the Nicaraguan people and to end the influence and the existence of American imperialism and intervention in Latin America. The case, although you wouldn't know it, is significant in three important, often unrecognized ways. First, it highlights Latin American contributions to the development of contemporary international law. Second, it underscores the importance of third world or shadow revolutions against imperialism and oppression in the development of international law. It is also demonstrative of how international law avoids the fundamental question these shadow revolutions pose, which are they and should they be considered in themselves and in international law just revolutions? The case in this way can serve as one among a body of cases, a line of jurisprudence and international legal issues, which are fundamentally about the justness of third world revolutions. Third, if we choose not to read this case in isolation from other salient revolutionary events which challenged the international legal order at the time in which this decision was rendered, we may see the importance of other shadow revolutions on international law. That is to say, it is important to note that the Nicaraguan ICJ case followed closely on the heels of the US intervention and invasion of Grenada. This US invasion of this small Caribbean country was widely condemned as illegal by most international lawyers, save a handful of realpolitik, American ones, and likely played a role in the strong stance the ICJ took on the peremptory norm of non-intervention. I have written on this if you'd like to read more about the Grenada Revolution and international law in the German Law Journal, which is open access. In this reading of thinking about revolutions not in isolation with each other, it can be argued that the Grenada and Nicaraguan revolutions together can be said to have shaped international law and the ICJ case. I'd like to return to the Cuban Revolution for a moment, as it shares some features of the Nicaraguan Revolution, which are important for understanding its position vis-a-vis international legal doctrines and events. Cuba's struggle for self-determination began with Spain after a long and brutal occupation of the island from 1511 to 1898. As many of you here in attendance already know, international law from the 16th century until the 20th century, and certainly the 21st century if you count Palestine, recognized that colonial states should exercise sovereignty over colonized territories. And international law also recognized that these colonial states could transfer such territory to another civilized state. International law recognized Spain's right and title to Cuba by way of discovery, occupation, and possession, and its right to cede that territory to the United States in 1898. Spain's defeat by the United States in the War of 1898 resulted in Spain ceding the territory of Cuba to the United States. And the United States at that time saw itself as facilitating a transition from Spanish rule toward Cuban independence. But instead, the victory of independence was taken away from the Cuban people and Cuban revolutionaries by an intervention and occupation, an American intervention and occupation, which was designed to create a state that was dependent on the United States, both economically and politically. As Nigel White has noted in his work on the Cuban embargo, the United States reserved the right to re-intervene, making its withdrawal conditional in the form of the Platt Amendment of 1901, and used the same method to secure a perpetual lease on the naval base of Guantanamo Bay, actions that clearly have undermined Cuban sovereignty. So the fact of this was that Cuban sovereignty was not absolute, but limited and mediated through a relationship of dependency with the United States. And following from this, it is absolutely no coincidence, in light of this history, that Fidel Castro would pursue a policy of active intervention in states to support revolutionaries or revolutionary governments, and the example being Angola's government in 1975, in ways which supported movements and struggles which resisted imperialism, colonialism, and neo-imperialism. So a Cuban reading of international law saw intervention as permissible and a necessary part of the United Nations General Assembly Declaration of Friendly Relations in 1970, which supported the right to self-determination. Cuba's revolution was not nationally framed. It sought to foster international solidarity for colonized and oppressed peoples whose self-determination, political, economic, and social, was being impeded by colonial or imperial power. Okay, part 4, the practices of epistemic justice in international law. How do we characterize, or how do we achieve epistemic justice in international law? How could I achieve this when thinking about producing legal knowledge about revolution in international law? In my work, I'm trying to trace, and I try to trace the influence of these shadow and third world revolutions to ask the pressing question, what changes when we consider the third world as authors and subjects of international law? What changes when we make revolution, as opposed to war, the focus of international legal understanding of the globe, its issues, and its struggles? What can revolution, as a unique form of conflict, tell us about the relations between the global North and global South in international law, in its doctrines, rules, norms, and institutions? I consider my work on Southern Rhodesia, Grenada, the concept of revolutions, and also my work here on Latin American revolutions such as Haiti and Cuba, just a beginning, just a start to answer these kinds of questions. There are many revolutions from Africa, South America, and Asia, and the Caribbean in particular, which have influenced international law, and very few international legal scholars are writing on this or take it seriously. The backlog of shadow revolutions is enormous and reinforces the prevailing legal epistemology on revolution, namely that there are some revolutions, predominantly white and Western revolutions, worth talking about and researching, and others unworthy of attention. Put another way, there are revolutions which sit on the Security Council of International Legal Epistemology, and there are revolutions which sit in the General Assembly of International Legal Epistemology. Undertaking a sociology of absences to understand the place and meaning of revolution in and for international law, one must also do this for all forms of legal knowledge which produce and reproduce these absences of the global South, of the colonized, of the oppressed, marginalized, and the voiceless. This requires not only having an account of knowledge, so not only saying, well, what is the law, what was the law in the ICJ decision, but also having an account of how this knowledge has come to be produced. Who produced it? What legal practices continue to produce it or enable it, and its absences or the peripheries in legal knowledge. As Upendra Bakshi suggested in his article on newly emergent geographies of injustice, the boundaries and the borders of international law are not just set by changing historical realities, but also by conceptual distinctions. I would add to this insightful observation that the boundaries and borders of international legal knowledge are not just set by what it includes and what's missing, but most importantly, understanding why. Thanks very much.
Thank you so very much, Vidya, for such a rich, fascinating and stimulating set of remarks. So much food for thought there, and unfortunately only 15 minutes, but we all need to go away and read everything you've written on this subject, and look forward to, of course, much more, right? This is an ongoing project. I'd like to invite those of you attending live to make your comments using the Q&A function on Zoom, and I'll put them to the speaker. So we have a question about the Latin American independence process. So the questioner here says that this isn't, it suggests that this isn't usually considered a shadow revolution in the region. So for example, Latin American states contributing to proposing uti possidetis as a legal doctrine. But this questioner says the white Latin elites fighting these revolutions themselves were simultaneously erasing their own shadow revolutions that were being led by, the questioner puts in quotation marks, the wrong kind of person, particularly indigenous revolutions. An example given is of the Tupac Katari revolution and the Puma Quechua revolution of 1810. So the questioner speculates maybe there is a shadow of the shadow, the product of white Latin American elites invisibilizing indigenous Latin the indigenous Latin American revolution. The questioner would love to hear your thoughts on this.
Oh, I'm happy to share my thoughts. So yes, I'm very much aware of this. And I was just reading a wonderful piece, again, by one of your speakers, Liliana Obregon, who wrote an article in this book, which I think many of you know, which is Latin America and the International Court of Justice. And she discusses this in the first chapter, which is identity formation, theorization, and the decline of Latin American international law. And I very much agree with her. And one of the things she notes, which I was going to mention this in my talk, and my talk was exactly 35 minutes and 11 seconds, by the way, which I've never been on time ever in my life. So this was the first for me. But one of the things she says is that she talks about the Congress of Panama. And she talks about Haiti's exclusion from the Congress of Panama. And she says that the reason for this was because of what existed, which was a white Creole consciousness that permeated among the elites of Latin American legal scholars at the time. And so she writes, Haiti's exclusion from the Congress of Panama gives further insight into the Creole identity. In 1816, 3 decades into the revolution and 10 years after its declaration of independence, Haiti's first president, André Pétain, supplied Bolivar with men, ships, guns, money, and a printing press in return for his vow to free all slaves. Although Bolivar recruited slaves in exchange for freedom and honored Pétion's as the author of our independence, he never complied with the promise. The Haitian government expected an invitation to Panama, but Bolivar and other Creoles feared that an implied recognition would promote slave uprisings in the continents. So as you rightly point out, the shadow within the shadow, or the fact that there are hierarchies within third world revolutions and revolutionaries, depending on the stratifications of race, religion, socioeconomic class, sexuality, all of those things does show up when we start looking at these revolutions more closely. So I entirely agree with that, with the comments of the questioner. I think more research needs to understand not just why, and I still do think that Latin American revolutions are really historicized as irrelevant because they were 19th century, and African and Asian revolutions and independence, and Latin American scholars getting frustrated and saying, we had our wave. We had the wave, a century ago. Sorry, I hope I'm not cutting out. In a way, the fact that the Latin American independence revolutions preceded the Asian and the African revolutions almost gave international lawyers an excuse not to consider it as contemporarily relevant. And so, yes, I think that would be my answer to the question, but thanks so much for it.
Great, thank you. So we have another question about this, specifically about Haiti, dealing with the kind of current situation there, but maybe I can kind of lead us to that with a question about of sort of my own, which is, I'm fascinated by your project because its breadth, which is appropriate, right? So in some ways you're doing comparative work, right? Comparative study, like your work on Arendt seems to be a comparative study of different approaches to national revolutions, right? And which are chosen as the comparators, and your critique of that in terms of its Occidental orientation. But that leads me on then to the question of the relationship between that critique and international law, right? Is that a critique of comparative study of revolutions? To what extent are you suggesting that somehow Arendt's view is an international law view of revolution, and that's the critique, or is that actually a sort of self-contained critique of Arendt, which is not in and of itself related to international law? And then sort of linked to that is then your concept of shadow revolutions, which include, or maybe cover entirely, maybe you could explain that, anti-colonial resistance, and that you're conceptualizing anti-colonial liberation and struggles for colonial liberation or freedom from colonialism as revolution. And I wanted to ask you, what is at stake in characterizing them in the language of revolution, as distinct from, say, anti-colonial liberation, and what is how these link to another categorization, which is, the conventional doctrinal categorization, which is self-determination, and to what extent you're critiquing self-determination, presumably as insufficiently self-determination provided legally by international law as insufficiently broad to serve revolutionary ends. I'm assuming you would take that view. And I suppose that how then these categories relate to each other, and that would then link to the question we have, which relates to the current situation now, right? Which is to critique. So one of the obvious critiques of self-determination is how it adopts a very formal notion of independence and freedom, which conceals all sorts of informal and ongoing relations of domination, which continue in the supposedly post-colonial arrangement. And international law of self-determination does not address that. the questioner is asking about the current situation and the recent situation of the issue of the role of NGOs in Haiti and the scandal over Oxfam, and that our questioner is doing a PhD on the legal accountability of NGOs, and asking you the extent to which that lack of accountability is linked to colonial mindsets and colonial ideology, and asking what actions could be taken to further decolonization in the context of the actions of IGOs. So a lot in that video, sorry, whatever you find interesting to respond to.
No, this is wonderful. These are fantastic questions. And I really like the framing, Ralph, of what you've posed to me, because the framing is, it's almost very often the framing I get about talks I give on revolution. And the reason why, looking at your questions, the reason why there's kind of a theme in terms of responses to these talks that I give have to do with what do we accept as an authoritative framework to talk about international law. So what are the boundaries already? So we know there are disciplinary boundaries. There are things that are international law and there are things that aren't international law. And then there are questions of comparative boundaries, which is what are the appropriate comparative reference? As you say, you picked Hannah Arendt. Was she a bit of a straw woman in the sense that she's picked the French and the American revolutions to focus on? And was I using her as that? And I think what I'm trying to do is something that goes to the underlying problems about revolution as a concept and event in grappling with it in international legal terms, which means that it's too slippery. It's a term which is ill-defined, and because it's ill-defined, that what happens is that there becomes different contestations of ownership in terms of what are we talking about? Are we talking about revolution as decolonization only? Are we talking about post-colonial revolution, where there are revolutions after states are sovereign? Or are we talking about revolutions in socialist terms, which are revolutions that are about changing political and economic and social orders, not necessarily only about imperialism? And the fact that it's so difficult to get a handle on a kind of common consensus in the invisible college about what are we talking about when we talk about revolution, speaks to something. So I have critiqued Arendt, but one of the things I really liked about her On Revolution book is that her first chapter, which is excellent, compares what she considers to be the two master processes of the 20th century. And the two master processes of the 20th century that form the 20th century, we know this from Britain in terms of the way Britain talks about the EU, is war and revolution. And my reason for kind of focusing on revolution and bringing it into international law conversations is, why is no one saying that, well, war is being talked about, war is always talked about. Not only is war talked about, we have fields dedicated to war and understanding it as a form of conflict, which has shaped centuries and also shaped the relations between states. We have conventions on it, we have treaties on it, we have international legal courses, the law of armed conflict, international humanitarian law, all framed around the concept of war. We have nothing on revolution. We might have a chair of war studies, we do not have a chair of revolution studies. So its omission, and this is not true for other disciplines. So when we look at Hannah Arendt in political theory, she had no problem talking about revolution to political theorists, philosophers even, political scientists, economic scholars, sociologists, all of them have a plethora of, and what I call reflexive studies, meaning they don't have studies just about revolution. They have studies about the study of revolution in their fields. And we don't even have the study of revolution in international legal thinking or in law generally. And so what is it about that omission, that epistemic challenge that revolution poses to our field, whereby our questions are always about how do we categorize this? Where does it fit in the typology? Because I want to be able to talk about it with authority, but it's got to fit neatly here and not here, right? And the messiness of it as an organizing principle is something I want to highlight, because it doesn't fit neatly within the typologies and categories of international law. And it breaks down those categories. So whether you're talking about whether it shows up in cases or in textbooks, it's often seen as background. So in order to understand this, the question of self-determination in international law, Cassisi writes, we have to understand these three revolutions. And he'll say the French, American, and Russian revolutions. And we have to understand that some of the norms that we have about international law come from those revolutions. And many third world revolutions don't. These are textbooks and they're always background. And I have to I'm trying to foreground the background and say what's missing from the background and why is it missing? And would it change what we talk about if we foreground the background differently? So that's kind of part of the reason. And it goes to your argument about, am I criticizing self-determination or decolonization? I would say let's not have fidelity to those categories if the discussion of revolution spills over. We don't need to say, well, it has to fit here. It can fit there, but it also doesn't have to fit there. Yeah, and then on the point of the questioner, which is such a great question, and I wish I was more of an expert in the field. What I liked about the question is, how do they say that there is a complete lack of an international framework for NGOs in third world countries. So to what extent is this result a result of colonial mindsets? And I would say, first of all, thinking about NGOs and the legacy of colonialism, and also its compatibility with mission, kind of missionary kind of zeal of civilizing that comes from so many centuries of domination of third world countries religiously and then through empires and states. There isn't enough work done on that. There isn't enough of a critique of the extent to which colonial mindsets purvey INGO's work and how does it do that? There's some work, I think, on it. And I think I have some friends and scholars at Leicester University who could probably offer some citations for that. It's not my field, but this goes to show about, the legacies of revolution and of colonialism and anti-colonial kind of struggles, why it's relevant today, like how and why it's still relevant today. So thanks for that question, but I don't have an answer, a specific answer of how do we frame, and this goes throughout the themes. I think, Ralph, I think you probably would say it's the theme running through many of the talks, which is how do we make what is seen as past relevant to the present, when the question is, it's relevant to the question, but how do we identify the present, but how do we identify its relevance? So it's not how do we bring the past into the present, but it's more like the past is in the present. To what extent are we able to recognize and understand and to figure out the significance and meaning for law and for people's lives today? Yeah, that's my terrible, I apologize, that's not a great answer at all.
That's a great way to end, actually, Vidya, because you have indeed very elegantly and eloquently encapsulated indeed one of the very important fundamental themes that have been running through this lecture series. So thank you very much, and for doing that off the cuff as well. Brilliant, thank you. But more profoundly, thank you very much for such a deeply insightful set of vitally important remarks on this hugely important subject, and also for giving up your precious time to prepare and deliver it. I'm so very grateful to you.
Yes, you've taken me away from marking, so thank you very much. I'm very delighted. Thank you very much. Well,
no, thank you. This brings an end to the lecture series for the present academic year. You can find recordings of most of the previous lectures posted on the website for the lecture series, and I'm delighted to say that Dr. Kumar has kindly agreed to have the recording of this lecture included on that, so thank you. I want to thank again my fantastic colleagues, Kat Balogan, Lisa Penfold, Jess Luong, and Danielle McFarlane at UCL Laws for their outstanding work on the practicalities. And my warm thanks also to my partner in crime, co-convener of this series, Alonso Gomendi Donkelberg, professor at the Universidad del Pacífico in Lima, visiting professor at Michigan, and tutor and doctoral student here at UCL. I want to salute all these people, and finally, the wonderful speakers, including today's speaker, Dr. Kumar. And I just encourage everyone to check out the videos of those past lectures, which videos will be included in, which are such a rich resource on a set of fundamentally important topics in international law. Thank you and goodbye.